If you've spent any time at all looking into estate planning, you've probably run into two very different camps shouting at each other. One says everyone needs a trust, no exceptions, and if you don't have one, you're basically setting your family up to lose a chunk of their inheritance to lawyers and court fees. The other camp says trusts are an overpriced scam that attorneys push on people who don't actually need one, and a simple will would do just fine. And here you are, just trying to figure out what's actually right for your situation, caught in the middle of two extremes that both can't be completely true. So let's just slow down for a second. Imagine a husband and wife, both in their early 60s, sitting at their kitchen table with two different brochures in front of them. One is from a financial seminar that scared them into thinking they need a $4,500 trust package immediately. The other is from a website that told them trusts are unnecessary unless you're a millionaire. They love each other, they trust each other, but on this one topic they cannot agree, because the information out there is designed to sell something, not to actually help them think clearly. That confusion right there, that's the actual starting point for almost everyone who eventually ends up with the wrong plan, or no plan at all. I want to use this video to give you the honest, no sales pitch version of this question. Not the version where the answer is always yes, because someone's trying to sell you a trust package, and not the version where the answer is always no, because someone's trying to seem edgy and contrarian online. The honest answer is that it depends on your specific situation, and by the end of this video, you're going to understand exactly which situation you're in. Before we go any further, I want to be really clear about who I am and who I'm not. I'm not an attorney, I'm not a financial advisor. I don't hold any professional license, and nothing in this video is personalized legal or financial advice for your specific situation. What I am is someone who researches this topic carefully so that you can walk into a conversation with a licensed estate planning attorney already understanding the basic landscape instead of walking in blind. Estate law is also not the same everywhere. It varies significantly from state to state, sometimes in ways that genuinely change which tool is the right one for you. So think of this video as your foundation, the thing that helps you ask better questions, not as a replacement for sitting down with a professional who knows the laws where you live. Here's why this question matters more than people realize. The decision of whether to set up a trust isn't really about trusts as some abstract legal product. It's about what happens to your family in the months after you're gone, at exactly the moment when they're least equipped to handle complications, because they're grieving. A poorly chosen estate plan, or no plan at all, doesn't really hurt you. You won't be there to deal with the consequences. It hurts the people you love most, at the worst possible time. That's really the stakes we're talking about here, even though the conversation often gets buried in legal terminology that makes it feel distant and abstract. So here's what I want you to walk away understanding by the end of this video. First, what a trust actually is and what it actually does, stripped of the sales language. Second, the specific situations where a trust tends to provide real, tangible value. Third, the situations where a will alone is often genuinely sufficient and a trust would just be an added expense without added benefit. And fourth, the questions you should bring to an attorney so that conversation is productive instead of confusing. If that sounds useful to you, go ahead and hit subscribe, because we're building out a whole library of these honest, no-pressure breakdowns on wills, trusts, probate, and everything in between, and you don't want to miss the ones that apply to your specific situation down the road. Let's start with the foundational piece, because I think this is where most of the confusion actually begins. A lot of people think a will and a trust do the same job, just with different paperwork. They don't. They solve different problems, and understanding that difference is the whole key to this video. A last will and testament is a set of instructions that only takes effect after you pass away. It tells the court who should receive your property, who should be the executor managing that process, and in some cases, who should care for any minor children. But here's the part that surprises people. A will has to go through probate. Probate is the court-supervised process of validating a will, settling debts, and distributing assets. It is run by the probate court in whatever state and county you lived in, and it operates on its own timeline, not your family's timeline. Probate can take anywhere from a few months to well over a year, depending on the state, the complexity of the estate, and frankly, how backed up that particular court is. During that time, assets are often frozen. The court has to confirm everything is in order before money or property actually transfers to your beneficiaries. There are also probate fees, which vary by state, plus attorney fees, plus the simple fact that probate records are public. Anyone can walk into that courthouse and look up what you owned and who you left it to. A revocable living trust works completely differently. Instead of your assets passing through your will and then through probate, you actually retransfer ownership of your assets into the trust while you're alive. You're typically still the trustee, meaning you still control everything. You can still sell the house, change the beneficiaries, dissolve the whole thing if you want to. Nothing about your day-to-day control changes, but because the trust, not you personally, technically owns those assets, when you pass away, there's no need for probate court to get involved in transferring them. The successor trustee you named simply steps in and distributes things according to your instructions. That's the headline benefit people talk about, avoiding probate. But here's the thing nobody mentions enough. A trust only avoids probate for the assets that are actually inside it. This is called funding the trust, and it is, without exaggeration, the single most commonly skipped step in the entire process. People pay an attorney to draft a beautiful trust document, and then they never actually retitle their house, their bank accounts, or their investment accounts into the name of the trust. If that happens, the trust is essentially an empty shell, and those unretitled assets still go through probate anyway, defeating the entire purpose. So a trust isn't a one-time purchase you set and forget. It's an ongoing commitment to making sure new assets you acquire also get titled correctly. There's also a meaningful difference in privacy and complexity. Wills become public record once they're filed with the probate court. Trusts generally do not become public record, since they're administered privately by the successor trustee, outside the court system. For some families, that privacy matters a great deal. For others, it's a complete non-issue. And in terms of complexity, a trust is genuinely more work up front. It costs more to draft, it requires that funding process I just mentioned, and it requires more diligence to keep updated as your life changes. A will is simpler, cheaper, and faster to create, but it guarantees your estate goes through probate in some form. Let me tell you about a situation I want you to imagine, because I think it makes this distinction land in a way that pure explanation sometimes doesn't. Picture a woman in her late 70s, a widow, who owns her home outright, has a modest investment account, and has 2 adult children who get along well and live nearby. She has a simple will that splits everything 50-50. When she passes away, her estate is straightforward. There's no real dispute, no blended family complications, no property in multiple states. Her estate does go through probate, and it takes about 7 months in her state, which feels long to her kids, but isn't catastrophic. The costs come out of the estate before final distribution, and it's an annoyance, but not a disaster. In that scenario, a trust might have saved some time and some modest cost, but it wasn't strictly necessary. The will did its job. Now imagine a different family. A man in his 60s, who owns a rental property in a different state than where he lives, has been married twice, has children from both marriages, and has a strained relationship with one of his adult kids. When he passes away without a trust, his estate doesn't just go through probate in his home state. The out-of-state property may require an entirely separate probate proceeding there, sometimes called ancillary probate, doubling the legal fees and the timeline. And because the family relationships are complicated, the public nature of probate creates an opening for disputes, for one side to contest the will, for tension that drags out for over a year. In that situation, a properly funded trust could have avoided the out-of-state probate entirely, kept the details private, and made the distribution process far harder to contest, because trusts are generally more difficult to challenge than wills. That family would likely have been genuinely better off with a trust. Same general topic, completely different answer, because the actual circumstances were different. That contrast is really the whole video in miniature. The question, do I need a trust, doesn't have one universal answer. It has an answer that depends on specific factors about your life, and now I want to walk through what those factors actually are. The first major factor is whether you own real estate in more than one state. This is honestly one of the clearest, most practical reasons to seriously consider a trust. If you own a vacation home in another state, or a rental property somewhere you don't live, your family could be facing two separate probate proceedings in two different state court systems, each with their own rules, their own timelines, their own attorney fees. A properly funded trust holds that property and sidesteps that entire ancillary probate problem, because the transfer happens through the trust's instructions rather than through each state's court system. The second factor is the complexity of your family structure. Blended families, meaning remarriages where there are children from previous relationships, are one of the most common sources of estate disputes in the entire country. When a will divides property among stepchildren, biological children, and a surviving spouse, the potential for someone to feel slighted or to actually contest the will goes up considerably. Trusts tend to be harder to contest successfully than wills, partly because they were typically created while you were alive and of sound mind, with more documentation around that, and partly because the structure itself offers more nuanced control, like specifying that a surviving spouse can use a home for their lifetime, but it ultimately passes to children from a first marriage afterward. That kind of layered instruction is much easier to build into a trust than a will. The third factor is privacy concerns. If you simply don't want the details of what you owned and who you left it to becoming a public courthouse record that any curious neighbour, distant relative, or journalist could look up, a trust solves that. This matters more to some families than others, and only you can really judge how much it matters to yours. The fourth factor is the value and nature of your estate. If most of what you own is already set up to avoid probate through other mechanisms, things like a 401k or IRA with a named beneficiary, a life insurance policy with a named beneficiary, or a home held in joint tenancy with right of survivorship with a spouse, then a trust might add less value than people assume, because those assets already bypass probate on their own through beneficiary designations. This is actually a critical point that gets overlooked constantly. A lot of people build an expensive trust and then don't realize that their retirement accounts and life insurance were never going to go through probate in the first place, trust or no trust, because beneficiary designations override a will or trust entirely for those specific account types. The fifth factor is whether you have minor children or dependents with special needs. For families with young kids, a will is still essential for naming a guardian. That part doesn't change. But a trust can be incredibly useful for controlling how and when an inheritance is actually distributed to a minor, rather than them receiving a lump sum the moment they turn 18, which, statistically, tends to go badly more often than families expect. For a dependent with special needs, a properly structured special needs trust can preserve their eligibility for government benefit programs while still providing for them, something a basic will distribution could actually jeopardize. The sixth factor, and this one surprises people, is your age and health trajectory. If there's a real possibility you could become incapacitated before you pass away, through a stroke, advanced dementia, or another serious illness, a revocable living trust includes built-in instructions for who manages your assets if you become unable to do so yourself. A will provides zero protection in that scenario, because a will only activates after death. Without a trust, incapacity often means your family has to go through a separate, sometimes lengthy court process called conservatorship or guardianship, just to get legal authority to manage your finances while you're still alive. That's a scenario people rarely think about until it's already happening to them. Now let's talk about the myths because there's a lot of bad information circulating on both sides of this debate, and I want to clear it up directly. Myth number 1. Trusts are only for the wealthy. This used to be more true decades ago, but it's outdated thinking now. The value of a trust today often has less to do with the size of your estate and more to do with the complexity of your situation, as we just walked through. A modest estate with out-of-state property or a blended family can benefit more from a trust than a large, simple estate with one home and 2 agreeable adult children. Myth number 2. Once you have a trust, you're completely done. No further action needed. This is the funding problem I mentioned earlier, and it cannot be overstated. An unfunded trust protects nothing. If you buy a new house, open a new investment account, or inherit property after your trust is created, those assets need to be retitled into the trust's name, or they'll still go through probate, regardless of having a trust sitting in a drawer somewhere. Myth number 3. A trust avoids estate taxes. A basic revocable living trust does not reduce estate taxes by itself. It's a probate avoidance and incapacity planning tool, not a tax shelter. Reducing federal or state estate taxes typically requires more specialized planning, often using irrevocable trusts, and that's a conversation specifically for a qualified estate planning attorney or tax professional, based on the current exemption thresholds, which do change over time and depend on your state. Myth number 4. Going the other direction this time. Trusts are always a waste of money pushed by greedy attorneys. This is just as misleading as the overselling. For the right situation, the family with out-of-state property, the blended family, the person worried about incapacity, a trust can save substantially more in time, legal fees, and family conflict than it costs to set up. The honest answer isn't, trusts are bad, it's, trusts are a tool, and tools are only valuable when they match the job. So here's how I'd suggest you actually approach this decision, step by step, in plain terms. Start by making an honest list of everything you own: your home, any other real estate, bank accounts, investment accounts, retirement accounts, and life insurance. Next to each one, note whether it already has a named beneficiary, because those typically bypass probate, regardless of whether you have a trust. Then think honestly about your family situation. Is it one marriage, biological children, generally good relationships? Or is there a blended family, estrangement, or potential for disagreement? Then consider whether you own property in more than one state, because that's one of the clearest, most concrete reasons to lean toward a trust. After that, think about your age and health. If incapacity planning feels relevant to your situation in the coming years, that tips meaningfully toward a trust, because a will simply doesn't cover that scenario at all. Once you've thought through those factors honestly, write them down, and bring that list with you to a licensed estate planning attorney in your state. Don't walk in asking, "Should I get a trust?" Walk in and say, "Here's my situation," and let them tell you which tool, or which combination of tools, actually fits. Because in most cases, the real answer isn't will versus trust, as if you have to pick a side in some big debate. Many solid estate plans use both. A revocable living trust to hold major assets and avoid probate, alongside what's called a pour-over will, which acts as a simple backup, catching anything that wasn't formally transferred into the trust and directing it there after death. That combination gives you a safety net, even if you happen to acquire something later and forget to retitle it. That's not an either-or decision, that's a complete plan working together. At the end of the day, this isn't really about legal documents. It's about whether your family spends the months after losing you dealing with confusion, court delays, and disputes, or whether they're able to grieve, support each other, and move forward without unnecessary legal obstacles standing in the way. The paperwork is just the mechanism. The actual goal is protecting the people you love during one of the hardest periods of their lives, and giving them one less thing to fight about or wait on when they're already hurting. So take what you learned today, be honest with yourself about which factors actually apply to your life, and use it to have a focused, productive conversation with a licensed attorney rather than guessing based on a sales pitch or an internet argument. Everything in this video is general education, not legal advice. Estate laws vary significantly from state to state, and the right structure for your situation depends on details a video simply can't account for. Before you make any decisions about a will, a trust, or any part of your estate plan, talk to a licensed estate planning attorney in your state who can look at your actual circumstances and guide you accordingly. Thank you for spending this time with me today, thinking through something that genuinely matters for the people you care about most. If this helped bring some clarity, consider subscribing, because there's a lot more honest, straightforward estate planning education coming, and I'd love for you to be here for it.